Supreme Court in SATISH Chandera AHUJA vs SNEHA AHUJA has held that a wife is also entitled to claim a right to residence in shared household belonging to the relatives of the husband. Hello everybody, I hope you all are doing absolutely well. In today's video, I will discuss about the judgment update in case of SATISH Chandera AHUJA vs SNEHA AHUJA, wherein I will discuss about the background of the case, the provisions on the basis of which judgment was passed, and the cases overruled by this judgment. Let's begin with the background of the case. Here, SATISH Chandera AHUJA filed a suit against his daughter-in-law Sneha, the sole defendant, for mandatory and permanent injunction, and also for the recovery of damages or mean profit. In the plaintiff, Satish Chandra pleaded that the defendant has filed a complaint under Protection of Women from Domestic Violence Act 2005, in which interim order directing the plaintiff not to alienate and not to dispossess the defendant without order of the competent court has been passed. He further pleaded that the status of occupation of defendant as daughter-in-law during subsistence of marriage with the son could be said to be permissive in nature, and defendant is not entitled to claim a right of residence against the plaintiff, that is, her father-in-law, who has no obligation to maintain her during the lifetime of her husband. In reply to this, in written statement, the daughter-in-law claimed that the suit property is a shared household as per provision of Section 2, Clause S of the Act of 2005, that is the Domestic Violence Act, and thus she has right to stay and reside in the shared household property. To this, the trial court decreed the suit filed by Satish Ahuja by allowing his application filed under Order 12, Rule 6 of the Code of Civil Procedure. Taking note of the admission made by the defendant in her pleadings filed in the domestic violence case that the plaintiff to be the owner of the suit property, the matter moved further, wherein the High Court, while setting aside the trial court's judgment, observed that the question that the suit could not have been simply decreed by the trial court on the basis of the title without weighing the effect of the statutory right in favor of the daughter-in-law. The High Court remanded the case back to trial court by issuing some of the directions. In appeal before the Supreme Court against the High Court order, the plaintiff placed reliance on Batra judgment to contend that the premises is not a shared household, since the husband neither has any share in the suit premises nor suit premises is a joint family property. This Supreme Court bench comprised of Justice Ashok Bhushan, R. Subhash Reddy and M. R. Shah. Now let's look at the Batra judgment. In S. R. Batra vs. Tarun Batra, the Supreme Court bench of Justices S. B. Sinha and M. Kadju in 2007 had rejected the contention that the definition of shared household includes a household where the property agrees, lives or at any stage had lived in domestic relationship. It held that wife is only entitled to claim a right to residence in a shared household, and a shared household would only mean the household belonging to or taken on rent by the husband, or the house which belongs to the joint family which the husband is a member. The court further observed that the claim for alternative accommodation can be made against the husband and not against the husband's in-law or other relative. Now, in the present case, the issues considered by the bench were the first, that whether definition of shared household under Section 2S of the Protection of Women from Domestic Violence Act 2005 has to be read to mean that the shared household can only be that household which is household of the joint family or in which husband of the aggrieved person has a share. The second issue was whether judgment in S. R. Batra vs. Tarun Batra has not correctly interpreted the provision of Section 2, Clause S of the Domestic Violence Act and does not lay down a correct law. Before going any further, we should know what a shared household property means. As per Section 2, subsection S of Domestic Violence Act, Shared household means a household where the person aggrieved lives or at any stage has lived in a domestic relationship, either singly or along with the respondent, and includes such a household whether owned or tenanted either jointly by the aggrieved person and the respondent, or owned or tenanted by either of them, in respect of which either the aggrieved person or the respondent or both jointly or singly have any right, title, interest or equity, and includes such a household which may belong to the joint family of which the respondent is member, irrespective of whether the respondent or the aggrieved person has any right, title or interest in the shared household. Referring to the words lives or at any stage has lived in a domestic relationship, the bench said that it has to be given its normal and purposeful meaning. The court also, referring to precedents, observed that use of both expressions means and includes in section 2 subclause S clearly indicates the legislative intent that the definition is exhaustive and shall cover only those which fall within the purview of definition and no other. The bench also observed from the above definition, following is clear. The first, it is not required of law that aggrieved person may either own the premise jointly or singly, or by tenanting it jointly or singly. The second, that the household may belong to a joint family, of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title or interest in the shared household. The third is that shared household may either be owned or tenanted by the respondent singly or jointly. Now, the living woman in a household has to refer a living which has some permanency. Mere fleeting or casual living at different places shall not make a shared household. The intention of the parties and the nature of living, including the nature of household, has to be looked into to find out as to whether the parties intended to treat the household as shared or not. As noted above, the Act 2005 was enacted to give a higher right in favor of women. This Act has been enacted to provide for more effective protection of the rights of the women who are victims of violence of any kind occurring within the family. The Act has to be interpreted in a manner to effectuate the very purpose and object of the Act. Section 2, subsection S, read with Section 17 and 19 of the same Act, grants an entitlement in favor of the woman of the right of residence under the shared household, irrespective of her having any legal interest in the same or not. The court also observed that the use of the expression at any stage has lived to protect the woman from denying the benefit of right to live in a shared household on the ground on the date when the application is filed she was excluded from the possession of the household or temporarily absent. The court observed that the object was not that wherever the aggrieved person has lived with the relatives of the husband, all such houses shall become the shared household, which is not the legislative intent. While overruling the S.R. Batra versus Taruna Batra judgment, which had adopted restrictive interpretation of shared household, the Supreme Court has clarified that the shared household under Section 2 of the Domestic Violence Act means that shared household of the aggrieved person where she was living at the time when the application was filed or in recent past had been excluded from the use, or she is temporarily absent. Domestic violence is rampant in country. The court observed that the right to occupation of matrimonial home was not so far part of the statutory law in India till Domestic Violence Act came. It also said that the progress of any society depends on its ability to protect and promote the rights of its women. Guaranteeing equal rights and privilege of women by the Constitution of India had marked the step towards the transformation of status of the woman in this country. The domestic violence in this country is rampant, and several women encounter violence in some form or the other, or almost every day. However, it is the least reported form of cruel behavior. A woman resigns her fate to never-ending cycle of enduring violence and discrimination as a daughter, a sister, a wife, a mother, a partner, or a single woman in her lifetime. This non-retaliation by women, coupled with the absence of law addressing women's issue, ignorance of the existing laws enacted for the women, and societal attitude makes the woman vulnerable. The reason why most domestic violence are never reported is due to the social stigma of the society and the attitude of women themselves, where women are expected to be subservient not just to male counterparts but also to their male relatives. This was the whole judgment that has been decided recently. If you like such video, don't forget to subscribe to my channel. I come up with such videos whenever a judgment updates comes. Thank you for watching my video.